Thank you. Always looking out for me. Court calls the case. People versus Virgil Dunlap.
There. Corey Burton here, assistant prosecutor here on behalf of the people.
Your Honor, Edward Dukas on behalf of Virgil Dunlap.
All right. Your name?
Virgil Dunlap.
Good morning, sir.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports. So I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a
I
reduction.
signed that.
Okay. Nothing else is holding him.
Any objection to the 28th?
No, Your Honor.
Probable cause conference, August 28th, 2025, 9 a.m. And will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the people versus Robert Gaylett. Yep. Got it.
Introduction of any of the people.
Asa Bashir for Robert Gaylett on matter.
Oh, I'm sorry.
Thank you.
Good morning, Rob Chico on behalf of,
Could you state your name, please?
Robert Gallant.
Okay.
All right.
Judge, I apologize. Ms. Reiser, may I approach with our chiefs?
Here now. Both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works. Robert.
And we'd request if it's possible to have a 1-week adjournment. I believe
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
someone from my office. Yeah,
What?
there's a trial. Mr. Killawald has a trial in 2 weeks, so it'd be possible to have a 1 week.
Why don't we see what date he's picking, adjourn it?
Probable cause conference, August 14th, 2025.
Go with that.
9 a.m. Bond will continue.
Thank you, Judge, for
Thank
your
you.
understanding.
Court calls case of the people versus Malik Wallace.
Ellie on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Malik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Eduardo Benavides.
Victoria Burton here, she's the assistant prosecutor appearing on behalf of the people.
When prosecutors and defenders start by waiving conflicts, it basically means, don't worry, Judge, we're cool, you can continue the case. Standard, but important.
Be conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask.
There was an issue?
Yes, sir.
Is that Miss Akinruli?
Yes. It's. Oh, yeah. No, she's not.
Oh, she's not the issue?
She's not the issue. Never.
Where is she?
Never.
Oh, Your Highness.
Good morning.
They were talking bad about you. I had your cover.
Brown though.
Yeah. Oh no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it.
You should.
Apparently they didn't finish.
Assistant Public Defender Chinad Kerry, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record, please.
Eduardo Benavides. Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine,
All
Judge.
right. During the matter, August 14th, 2025, 9 a.m. bond continued.
Thank you.
Thank you. Let's call the case of the people versus Brandon Bowman.
Ally Zinn on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. You state your full name for the record, please.
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I could address bond, Your Honor.
Okay. Are you going to address the conditional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Freshour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report since being put back in for violating the law.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your
Mr.
Honor, I haven't seen anything about these calls. My client is saying that he's,
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull it up my internet and not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Mulvey, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay? So get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up real quick.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm going to deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
that I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm going to need one for your friend there.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your history. Yeah, man, I'm just a figurehead. Court calls the case People versus Anthony Miller. The keys in.
Your Honor, Alexis Pluma appearing on behalf of Mr. Miller.
Mr. Miller, can you state your name, please?
Anthony Lavelle Miller.
Thank you.
Your Honor, I am going to ask to address bond first, if you would allow it.
It's gonna have to be brief.
Okay,
Otherwise, you're gonna have to file a written motion, show back up at 4.
okay, understood. Briefly, Mr. Miller's bond was originally set because he failed to appear for a hearing last fall. I do have proof here that Mr. Miller at that time was incarcerated in the Wayne County Jail. He was in from September 2024 to April 2025. He would like you to consider a personal recognizance bond on his behalf because he has a part-time job.
How did he come back into custody?
I believe he was picked up.
So he didn't walk in after he left his time in jail?
He was in Wayne County, then taken to Oakland County, then transferred here. So he was released from Wayne County at the end of April of this year, then went to Oakland, and then was transferred here. So he was not out of custody at any point in time.
That's what I'm asking.
Yeah.
Said he was picked up.
Picked up from another jail is, I guess, what I meant to say. And he would be staying at the Delanis Center if released, but he does have his sisters who live in the area.
Any response from the people?
Your Honor, we can leave it in the court's discretion, starting with the retail bond, so he's in custody. But this isn't his fault. I mean, retail bond.
What was his previous bond set at?
He had a personal recognizance bond prior to failing to appear last fall.
Why do I have 25,000 cash surety? Well, doesn't matter. I'll grant that motion. I'll set his bond at $25,000 personal recognizance bond previously stated.
Understood. And Your Honor, I do have a green sheet for him. We're just requesting a 2-week adjournment.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continues. Thank you.
Thank you.
Case People versus Robert Carl.
Your Honor, Alexis Kumai again on behalf of Mr. Carl. And Mr. Carl, could you say your full name?
My name is Robert Martin Carl.
I have before me a plea form that the defendant is going to be pleading to guilty to account 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right. May I have him sworn?
Okay. Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, nothing but the truth?
Oh, sure, I do.
State your name.
My name is Robert Martin Carl.
All right, sir, it's court's understanding you're going to plead guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $1,000 fine plus court cost.
I want to be accountable for that, sir. Yes, sir.
What?
I want to be accountable for that, sir. Yes, sir.
Okay, so you understand the maximum penalties in the charge?
Maximum should be a year.
Will be up to a year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, sir, I do.
All right. And understanding that, do you still wish to plead guilty?
Yes, I do, sir.
All right. You understand also, sir, that I will not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that, sir?
I never know that, but okay, sir.
All right. Did you want to discuss that further with your attorney?
My attorney
You're gonna be sentenced in Ypsilanti. Judge Barr, that's where all your other cases are. So Judge Simpson's not gonna send you. You'll be back with me, Ypsilanti.
Or we'll just do it here.
Everything. Yes, sir.
All right. You want to proceed?
Proceed.
All right. So to that charge, how do you plead?
Plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
All right. You signed an advice of rights form. Is that correct?
I did, yes, sir.
Okay. You have any questions regarding any of those rights?
No, I appreciate your consideration, and I'm accountable for the thing.
Okay. I need you to look at paragraph 5 on that form. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir, I understand clearly.
You understand you're giving up your right to appeal of right.
That'd be part, yeah, no
You
comment.
understand that?
Yeah, I take that, yes.
All right. Are you on probation or parole?
That's incorrect, sir. It's a hard no, sir.
Okay.
I mean, no.
Okay. I'll try that again because I want to make sure the record.
No,
is
sir.
clear. Are you on probation at all at this point?
No, sir.
Okay. Are you on parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No promises made that I did not.
All right. Has anybody threatened you or coerced you in any way?
No, sir, they haven't.
You're doing this voluntarily?
This is the,
Okay. You're doing this of your own free will?
Yes, sir, that's correct.
All right. And you're also doing it because you believe that you're guilty of this offense, sir?
I am.
Okay. All right. On the date of March 27, 2024, at the location of 220 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes, but no. No. Yes, I was. I just go with that. But yes, I was.
Okay, let's try this again.
Yes, I was, sir.
Okay, let me ask the question. On the date that I just mentioned and at the location,
Yes, sir.
did you have cocaine in your possession?
Yes, sir.
Well, did you?
Yes, sir.
Okay. Did you use the cocaine?
Given a chance, I would have.
Okay, so you didn't use it.
I did use it. I was using cocaine. I had cocaine and I was using it.
So you did use it?
Yeah.
Okay. Did you know what you were using was cocaine?
I was very advanced on that information. Yes, sir. Yes, sir. Keeping it simple.
So, sir, if any of what I just say is incorrect, let me know. On that date and at that location, you had cocaine in your possession, you used it, and you knew it was cocaine. Is all of that correct?
That is all correct.
Thank you. All right. Now, sir, I have to advise you that if between the time of this plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, nor would the judge be bound by any evaluation in this case. You understand that, sir?
Yes, sir, I do. Correct.
All right, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
August 13th at 10 a.m.
August 13, 2025, 10 a.m. before Judge Barr.
And Your Honor, very briefly, if the court would consider a personal recognizance bond now that Mr. Carl has pled, he does have just recently got his own home in Ypsilanti through a VA housing voucher, and he is concerned about potentially losing that housing if he stays in custody. He does know what he would need to do in order to get out, and this is the only case that's really holding him. He does have other cases out of 14A2, with low nominal bonds set, he could afford to post those, but not the bond on
I'm
it.
going to leave that choice up to, I'm going to deny the request at this point. I will leave that to Judge Barr, who will be able to take everything into consideration regarding this gentleman. So your motion for bond reduction is denied at this time.
Understood. Thank you.
Court calls case People versus Jerry Bigham. So it must have been, he must have been at
Andrew Madison.
Austin Lacey on behalf of the defendant, Your Honor.
Your name, Jerry Bigham. Don't bang on my podium. What are we doing?
Yes, Your Honor. At this time, my client is wishing to waive his preliminary exam and seek an offer in circuit court.
Sir, is that correct?
Yes.
Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes.
Thank you, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
The people waive the right.
Preliminary examination having been waived, defendant bound over to circuit court on both counts. Mr. Belvis.
Your Honor, we acknowledge the information. Thank you. At this time, my client waives formal readings and stands mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 18th at 1:30, Judge Slay.
September 18th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Sean Dorsey.
Andrew Children, on behalf of the people. Morning, I'm Mike Getty, Assistant Public Defender on behalf of Mr. Dorsey, who's here to my right and beat me here by a mile. State your name for the record.
Sean Dorsey.
Your Honor, this is the first PCC. We are requesting a brief adjournment so that I've had a chance to speak with Mr. Childers so that we can continue to discuss this matter. We're also going to see if we can't work a release to a treatment in this case.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you. Court does call the case of the People versus Michael Boyce Smith.
Good morning. Amy Meiser, on behalf of the people. I believe this is.
Yes, it's Miss Akin release case once again.
She was just reviewing the
What, she's reviewing what? Video?
video of it. She couldn't get it open, but ours open.
Oh, was she in with, were you in with your client reviewing video?
I was, Your
You've
Honor,
had
but
quite a week.
it's, I have, you know.
Yeah, I know.
Yes.
Because all of it's happened in front of me.
We've been
It's
together.
been a
all
mess.
week.
I'm surprised you're still standing.
Just hold it together, Judge. Try it. Good afternoon. No, it's still morning. Good
It's
morning,
still
Your
morning.
Honor.
Yes, it is.
Assistant Public Defender.
You want me to pass it so you can look at?
No, it's okay, Judge.
Okay.
Yes.
What would you like to do?
We would like to adjourn this matter. The court should be in receipt of a green sheet.
All right. Probable cause conference will be adjourned August 14, 9 a.m.
Thank you, Judge.
Thank you. She's had a day. It's only been 2 days, but.
And I had a docket after we left.
What did you say?
I had a docket after we left till 6:30 yesterday.
Did you? You are my hero. Court calls the case, People versus Robin Finney.
Andrew Children, on behalf of the people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Ms. Finney, who is standing to my right. Please state your name for the court.
Yes, Robin Lee Finney.
All right.
And Your Honor, I am hopeful that we will be able. I did send over pretty substantial mitigation, including this newspaper article about all the work my client's done in the community to Mr. Childers. So he is reviewing that, and I think going to have a conversation with his witness. So we're asking for a brief adjournment.
Probable cause conference, August 14th, 2025, 9 a.m. Bond continued.
Okay, August 14th. We'll be in touch. Good luck. Thank you.
Court calls the case, People versus Savannah Bradley.
Corey Burke, prosecutor. And Laura Yagi, Assistant Public Defender with and on behalf of Ms. Bradley, who's approaching.
New case. Competency. This is huge. If someone is not mentally competent, the trial pauses completely until doctors say otherwise. Fatima appearing on behalf of?
In terms of the substance, the PCC, Your Honor, we're requesting an adjournment. Ms. Bradley is very eager to get into treatment. We have spoken. Unfortunately, she works a lot, so we played some phone tag. I do want to address the bond issue.
So do I.
Yes. So initially, when I first spoke with her, she indicated that she was not aware that it was such a tight time frame within 24 hours of her release, that she was expected to do an intake. She followed up with them, and she did make contact with them, scheduled an appointment. Unfortunately, she didn't realize it was the same time as a psychiatric appointment she had. So she went to her psychiatric appointment, and then she was basically calling them and calling me, waiting for them to call her back. There was a misunderstanding there. I think it was 2 days ago or yesterday, I told her, just go, don't even wait for them to call you, just go. And she was at work and she wasn't able to get there before they closed. So I did tell her first thing this morning to go, but by the time they opened, she was already here. And so we are asking for the opportunity for her to go test today or for her to check herself in.
But after that point in time, she had no further contact with them.
So she is saying that she did call them repeatedly after the 23rd. I know that's not in their report, but that is what she is saying, is she called them and she left.
Very clearly says she failed to report for her intake appointment as ordered. No further contact has been made.
I understand that's what they say. She's saying she tried to call them. Her dad is with her in court today.
So, and when she tried to call them, what they say to her?
She left a message, I think.
And nobody called her back?
That's what she's saying.
Really?
I just want to make two other points. So first, she is a working mom. She is a 9-year-old. I believe she's sole care 9-year-old, right?
If she went over, would she test clean?
I don't know. I think so. I mean, based on my conversations with her, I will also say.
I think it's like a clearest question one can ask.
Okay, she's saying she would test clean, and she's saying she is prescribed to Adderall, and that's what she would test for.
And that's the only thing that's going to show up?
Should, yeah.
Will or should?
Will.
That's it.
Yes.
I'll tell you what I'm going to do. I'm going to give you a shot. She needs to go over right now to community corrections, do her intake, take her test, and if you could let them know she's on her way over. If anything, tell them also that if anything comes, you need to come back over here. But if they get the test before you get back over here and something else shows up, take her into custody.
Understood. She is prescribed that medication, like I said, but.
I heard.
Understood, Your Honor.
Get over to community corrections. I'll pass the matter. Court calls case, People versus Matthew Fonseca.
Good morning, Your Honor. Public Defender Carson Lubez on behalf of Ms. Fonseca, who's present to my right. Can you state your full name for the record, please, Matthew?
Matthew Fonseca.
Thank you.
Your Honor, today is the date and time set for probable cause conference. At this time, we're respectfully requesting to step for exam on both matters.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 12th. Preliminary examination, August 12th, 2025, in person, before Judge Valvo, in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case, People versus John Altcock.
Yes.
Stephanie Kane on behalf of Mr. Occult, who's appearing by Zoom. Mr. Occult, could you please state your name for the record?
John Paul Alcolt.
Your Honor, at this time, we are asking that this be set for a preliminary exam.
Discovery is complete.
To my knowledge, yes.
And would the people have their witnesses available the 12th?
That should be fine.
Pardon?
That's fine.
All right. Preliminary examination in person, August 12th, 2025. 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond continue. Thank you.
Thank you.
Court does call the case of the People versus